Start. Para. Convict for offence under section 376 of the IPC is hereby questioning the judgment and order dated 21/10/2002 passed by second additional ad hoc sessions judge Aurangabad in sessions case number 103 of 2001. Para. 6-year-old daughter of informant was unwell. She was taken to doctor who prescribed medicines, but there was no improvement. Informant called his brother, who advised bringing an occultist, as he suggested that deceased daughter was possessed by evil force. Informant conceded, and his brother brought accused, who claimed himself to be a mantrik, and he assured to treat deceased upon charging rupees 250. He directed informant to purchase necessary material, and under the pretext of exorcising and driving out spirit, he committed rape on the minor. Her condition worsened, and while being taken to the native, in the journey itself, she breathed her last. Parents performed last rituals, and later on informant came back to Aurangabad and lodged a report, which was made the basis of registering crime bearing number 24 of 2001 for offence under sections 302 and 376 of the IPC. Para. PW8 Nikam in bracket PSI bracket close and PW9 PI, both police officers, conducted and concluded investigation at respective times, and finally accused was charge sheeted and made to face trial before learned second additional ad hoc sessions judge Aurangabad, who, on appreciating oral and documentary evidence adduced by prosecution, held charge under section 376 of the IPC to be proved, but acquitted accused from offence under section 302 of the IPC. It is the above judgment and order of conviction under section 376 of the IPC which is now taken exception to. Learned counsel for the appellants would submit that conviction is challenged primarily on following grounds. Firstly, there is inordinate delay in lodging the FIR. Secondly, there is no medical evidence in support of charge of rape. Thirdly, false implication at the behest of a corporator. Fourthly, inconsistency, material omissions and contradictions in the versions of parents of victim and PW7. Emphasizing the above grounds, learned counsel for the appellant would vehemently submit that there is no convincing evidence in support of the case of prosecution, that prosecution in fact had failed to establish case beyond reasonable doubt. Learned counsel took this court through the charge and pointed out that apart from allegation of rape, there was also charge of committing murder, but on the same set of evidence, learned trial court has already acquitted appellant from charge of murder. However, unfortunately, guilt is fastened for offence under section 376 of the IPC. Learned counsel would point out that apart from inordinate delay of almost a month in implicating accused, there is no supporting medical evidence suggesting evidence of rape. She further pointed out that prosecution is merely relying on evidence of parents, that is PW3, father of victim, and PW4, mother of victim, but according to her, they both are not lending support to each other and are rather giving inconsistent versions, and that their evidence is full of material omissions and contradictions. Para. She further pointed out that it has come in the evidence of parents about presence of other independent 10 to 15 persons at the time of alleged occurrence, but none of them is examined. Consequently, it is her submission that there is no convincing evidence, but still learned trial judge has accepted the case of prosecution as proof, and so she prays to allow the appeal by setting aside the impugned judgment. Per contra, learned APP strongly oppose, pointing out that complainant parents are residents of Latur and they have shifted to Aurangabad, that informant father is illiterate and was working as a watchman for livelihood of his family, that moreover he belongs to Latur and had shifted to Aurangabad to earn, being illiterate after death of his daughter. Instead of reporting to police station, he spent time at his native and subsequently he returned Aurangabad and lodged report, and hence there is delay, and according to him in cases of such nature delay is insignificant. Stop.